Hello viewers, welcome to yet another Tête-à-Tête with me and Subathra. After copyrights and trademarks, we are rounding off the IPR discussion with patents. Hi Subathra, please initiate the viewers to patents.
Thank you, Sandhya. Now talking about patents, let's get to the basics. So first is the meaning of patent. So simply put, a patent is nothing but an exclusive right which is granted to an inventor to make or sell his or her invention for a specified period of time. So here the aspect invention is key, and such right is granted by the government as such. Now, to cite, for example, these examples are age-old examples, but still, Alexander Graham Bell, I think everybody knows, he invented the telephone and he completely changed the face of communication in the world at that point. And the telephone itself was patented in 1876. And the other example is, again, a very common example which we have all been through, which is Thomas Edison, who invented the light bulb in 1879. He applied for patent for the light bulb or the incandescent lamp, which revolutionized the way the world lives to date. I can't imagine how the world will be without lights.
Light.
And he was granted the historic patent in 1880.
Subhadra, I'll take you from a few of your examples, like you spoke about Alexander Graham Bell and the telephone. Apple's iPhone, the iconic phone that changed the smartphone business, also is one of a kind invention. It got its patent in 2007. Okay, back home, there is a very interesting example. In India, the very first patent happened in 1856. It was called a pankha pulling machine in Hindi, or a simply basic version of an electric fan. It was patented in 1856 by a Calcutta-based inventor called George Alfred Depenning.
Right. Now we will talk about the need for patent. Now, patents deal with invention of a person, and like trademarks and like copyrights, patents are also intangible assets, as it has got to be, because it is with the knowledge of a person it is created, and it is necessary to protect the creation of a person in such a way that they benefit from it economically and otherwise. Else it is open for use by any third parties and it is more of exploitation. And patent can be granted for a product, for a machine, drugs, or process manufacturing as well.
We'll now look at the laws that govern patents in India and elsewhere. Primarily in India, the Patents Act of 1970 is the mother legislation governing all patents, registrations, etc.
Right.
Besides, like trademarks and copyrights, the Trade-Related Intellectual Property Rights Agreement, or the TRIPS agreement, comes into play. Now, India became a member of the World Trade Organization, WTO, in 1995, and consequently signed the TRIPS agreement, which governs all the three legislations. Why I'm mentioning this here is because up until the time we signed the TRIPS agreement, India as a nation signed the TRIPS agreement, the Indian Patent Act allowed only for patent of processes and not the products. So, for example, if I could make the same end product as you make using a different process, that was allowed. But consequent to signing the TRIPS agreement, the major amendment happened in the year 2005 in the Indian Patent Act also, to bring it in line with the TRIPS agreement, by stating that even products could be patented. This was most suitable for the pharmaceutical industry.
Now, we will look into the things which we have to be kept in mind while registering the patents. Now, there are about three things which we have to keep in mind while we do the registrations as such. One is, it must be novel and non-obvious. So there has to be some new and originality in the invention or an inventive step in it. So it must be different than all the other products or the process which is already there in existence. For example, the Wright brothers invented the airplane. At the time they invented it, nothing of that sort of an airplane was in existence.
Right.
So it was novel, which is new, not because they were the first to think of flying, but they were the first to think of flying in an airplane.
Right. The second aspect that is looked into by the patent authority before patenting is that any invention must be unique. Now, when I say unique, it must be one of its kind. If we had to look at an example, let's take the example of a Bluetooth. Now, a Bluetooth basically uses high frequency radio waves to transmit data at short distances, and you really don't need a wire connect to it. It is so one of its kind when it was brought in. It got patented in 1997. Of course, after that, the original inventor patented it in 1997, and all of it was assigned to Ericsson, which the mobile maker, which now holds majority of the Bluetooth patents.
The third point is it must have an industrial application. It must be capable of being used in any industry. This means that the product or the process must have some utility or a practical application for it to be patented.
Right.
Now we have to see what cannot be patented as such. So Section 3 of the Act contains a whole list.
Correct.
And we are going to mention a few of them here. One is the frivolous invention, which is an invention that does not have any serious value at all. For example, years back, we would have heard about this Ramar Pillai, who said he was able to invent herbal fuel. So it is a very famous case, and his patent was also rejected on this aspect of saying it was a frivolous invention.
Another product or process that cannot be patented, which is outside the purview of patent, is an invention whose use is intended contrary to the society, to law, to morality, or is injurious to public health. For example, any experiment done by a scientist by releasing any gas or substance or organisms which are actually end up hurting or injuring the public good or society at large.
The mere discovery of a scientific principle or any living, non-living substance or organisms or a combination of mixtures which results in a combining properties of already existing substances.
Also, a method or methods of agriculture and horticulture, and any invention related to atomic energy cannot be patented.
Any process for the medicinal, surgical, curative, prophylactic, or other treatment of human beings or animals are not patented.
Plants and animals in whole or part, or any organisms, microorganisms which are discovered cannot be patented, obviously, because they're only discovered and there's nothing new in them. For example, as recent as in 2022 May, there was a species of a monkey which was long-limbed and long-tailed called the Papa langur, which was discovered. Obviously, there can't be a patent for that. Similarly, a new species of tree was discovered in the Amazon forest, which had medicinal and curative values, can't be patented as well.
Any mathematical or business method or a computer program per se or any algorithms cannot be patented. Plus an invention which is in effect, which is in traditional knowledge.
We will now look into the duration of patents. For utility patents, they have a 20-year term from the date of filing the patent application. When it comes to design patents, their term of registration is for 15 years from the date of filing the patent application.
It will be discharged into a public domain for public use when they expire. This means that invention will be available for public use as well.
We now look at the rights of the patentee. Once granted a patent registration, the patentee, who is also the inventor, they are used interchangeably. They enjoy certain exclusive rights, like in case of the other IP laws as well. Typically, the rights are classified into product rights and process rights, or product patents and process patents. Let's look at the product patent. If a product patent is granted, only the inventor can make, use, sell such products as such. Third parties, in order to make, use, or sell, have to get the original inventor's prior consent to take it forward.
Now, coming to the aspect of process patent, only the inventor can use the process to make the product, which can be made, used, or sold.
Right.
Third parties have to obtain the original inventor's consent to use it. In case there are two or more original co-owners to a patent, they have equal share over the patent. If one co-owner wants a license or assign the patent, he or she can do it only with the prior consent of the other co-owners.
Right. We now look at the concept of patent of addition. Now, if an invention has already been patented, and then there is some improvisation or modification to such an invention which is already patented, then such improvisation or modification can be filed additionally for patent. That is why it's called patent in addition. One has to keep in mind, it's a very thin line, but it's a line nevertheless. One has to keep in mind that only an improvisation or modification of the existing invention patented will be considered as patent in addition. If it is an altogether new invention or an inventive step, you have to go for standalone patent registration. There were several case laws highlighting this thin line of difference, but one of the landmark cases was Ravi Kamal Bali versus Kala Tech and others. This decision was passed by the Bombay High Court in 2008.
The duration of the patent of addition cannot exceed the original patent. For example, if an original application of patent was filed in 2010, then the term will be for 20 years. So the original patent will be valid up to 2030. If a patent of addition was filed in 2015, even then its duration will be only 2030.
Like with the other two IPR laws, we cannot but not discuss the infringement aspect. So we do so in patents as well. So when an already registered patent, be it a product or a process, it is unauthorizedly used by a third person other than the original inventor without getting prior permission, then it amounts to infringement.
There are no express provisions in the Patent Act as to what constitutes infringement. However, one can draw inference from the rights of the patentees relating to the product and the process patents. So any usage of either the product or the process patent without prior consent of the original inventor or the patentee will amount to infringement.
Some time ago in the episode, we just discussed about the Patent Act being amended several times, and the latest one being in 2005, which was also the most crucial amendment, simply because it introduced the concept of products being patented as well. And this was especially true for the pharmaceutical industry. However, in the same year, the amendment, something called the Efficacy Clause was also introduced, probably keeping in mind the pharmaceutical implication that it has. New forms of already known substances had to pass the test of enhanced efficiency in order to be patented as a product.
Now, at this juncture, I think we should look at the most landmark case, which is the Novartis versus the Union of India. I think it's a very, very famous case. And let us just glance into a brief facts of this case. Now, Novartis AG, as everybody is aware, is a Swiss-based pharma giant. In 1997, it filed an application in India to grant a product patent to an anti-cancer drug, which is known as the Glyvac. It was used for in chemotherapy. It based its application that it has invented a component called as Imentiv, a beta crystalline form of a salt. However, back then the Indian patent law did not allow product patents. Hence, the case law was in limbo for almost 7 years. In 2005, when the Patent Act was amended to include the product patents also, Novartis reinitiated the patent case. But the Madras Patent Office rejected the application on the ground that a known chemical can only be patented in novel forms that have improved efficacy. But the Patent Office did not find any new therapeutic efficacy in Glyvac or the Imentiv salt.
Right.
On appeal, a two-judge bench of the Supreme Court upheld the rejection of this application on the basis that there was no enhanced efficacy. Another issue was the high pricing of the drug. Now, if you see, there are similar issues were also discussed in other cases like F. Hoffman La Roche Limited versus the Cipla Limited case, which is based out of Mumbai.
Subathra, if you recollect, in our lottery October 2020 edition, we had highlighted how India as a nation had taken the lead along with South Africa in submitting a proposal to the WTO, World Trade Organization, requesting for a waiver of patents, especially on vaccines during the pandemic 2 years.
Right.
More than a year later, WTO approved a limited patent waiver for all the COVID vaccines, medication, equipment, etc. While the waiver is a hot topic for discussion and debate, India was specifically applauded for taking the initiative to ensure some amount of equality in accessibility of patented vaccines and everything to developing countries such as ours. So this itself indicates the importance of patents and the remaining IP laws as well. Your thought?
Yes. One can also observe that a large chunk of patent infringement cases pertains to the pharmaceutical sector.
Correct.
If you are an inventor, it allows you to the exclusive right of usage and the benefit for a limited period of time. It also allows competition to be kept on hold. This in itself is an indication of the growing importance of intellectual property laws, especially patents in our everyday lives. To a large extent, I would like to say we would see a lot of filings happening on the aspect of patents in the pharma sector and also in the medical field, yes, compared to any other sector.
Yes.
And I think as we have a long way as such to go further into our patent laws and look and think more futuristically how to promote and to keep the patents tight in our country and also around the world.
Yes.
We would like to actually thank the viewers for watching our video clips. So we have made a great attempt from right from the beginning talking about the intellectual property laws, right from the trademarks to copyrights, and we have wound up with the patents now. So I hope all of viewers would have enjoyed the video, which I hope is informative. And we have done our best to put it in a very simple language.
Yes.
And we will be coming up with a lot more interesting topics in the upcoming editions. I hope all of you will enjoy. And please do share your comments and feedbacks. We'll be very happy to look into that. And also, please do share any topics of interest which will help us to talk to you all about. We'll be very happy to do that as well. Thank you so much. Thank you, Sandhya. Thank you so much.
Thank you. Bye.